Good morning. My name is Ron Fox, and welcome to the Fox Smith Legal Symposium, free to our clients every year. I want to welcome you to the seminar, and I want to thank you for attending. At Fox Smith, we understand that every matter that is sent to us is important to our client, and we treat it as such. When we get a new matter in, we work very hard to make sure that we immediately contact our clients and talk to them about what it is their goals are. We work collaboratively with our clients in an effort to make sure that they obtain an effective and efficient result promptly. We also take it as a real honor when clients send us work. And today's seminar is our effort to say thank you for the trust that you have placed in us when you send us new matters. Today, you're going to hear from a number of my partners. All of them are experts in the fields on which they're going to be speaking. We sent you an email earlier which provided you with the biographical information for each of those partners, and you can see from looking at those that they each have a great deal of experience and knowledge about the areas that they're going to be talking about. We also provided you with a listing of the different areas of law in which we practice. That should help you understand the kinds of service that we can provide. Today we're going to talk about three topics. One is employment law, especially in the era of this pandemic. The second is risk management and litigation avoidance. And the third is what happens when you're involved in a lawsuit. What are the first things you should do when you're sued? What are things that should be done as you proceed to defend yourself? And how do we evaluate cases? Before we begin, there's just a few preliminary matters I want to describe for you. First of all, I want to say thank you to Alaris Litigation Services. Because we could not do this live and had to do it virtually, we had to rely upon a top-notch videography company to provide that service to us. And Alaris Litigation Services has graciously agreed to provide that service to us free of charge. Second, I want you to know that we sent you an email just a few days ago in which we provided you with the PowerPoint presentations that you'll be seeing on the screen today. So you have those available to you for future reference. Also, these seminars are very important to us and they're important to our clients. And we make a real effort to try to communicate effectively on topics that clients are interested in. And so we would ask that at the end of this seminar, you respond to an email that we're going to send to you. In that email, you will see an evaluation form, which gives you an opportunity to rate our performance. It also gives you a chance to tell us topics that you would like for us to speak about in future seminars. Also, please know that because of the limited time that we have during the 2 hours that we're going to do this seminar, and because of the virtual nature of the seminar, we really can't take questions as we make our presentations. But if you have questions, please write those down on the evaluation form and send them back with the return email that you send to us. As our way of saying thanks for giving us the evaluations, we'll send you papers that cover some of the topics that we're going to discuss today. We are grateful that you are attending the seminar with us today, and I want to say thank you, and I hope you find it helpful and informative.
Thank you. My name is Bart Sullivan, and I'll be speaking to you today regarding alternative dispute resolution and touch briefly on COVID-related insurance coverage, a topic that's near and dear to many of our hearts at this point. Alternative dispute resolution. What is it meant to be? Ideally, it's a cost-effective way to keep companies out of court and away from the kind of extended litigation and the costs that go along with that, that invariably cost those who win as much as it costs those who lose. What does ADR too often turn out to be? Essentially a mini trial, a quasi-judicial proceeding that looks and appears to a lot like litigation that it's supposed to be replacing, complete with judges, attorneys, motions, discovery practice, expert witnesses, and too often awards that look like excessive jury verdicts. But successful ADR can be accomplished. It can be done at lower cost with quicker dispute resolution, which will help your company's cash flow and also help you preserve and sometimes even improve company relationships. Because in the end, we want to stay away from the type of litigation that can harm those relationships. To be successful with alternative dispute resolution, and we'll talk about some of the various forms that can take as we go, you really need to answer two questions. The first is it more important to your company to win at all costs? Or is it preferable to hold down costs and the risks that go along with the disputes, and to preserve relationships with the company, employees, and customers? If you're the type of company that feels like you need to win all the time, alternative dispute resolution may not be for you. To make it work is going to take the commitment from everybody in the company, starting at the very top. Because if they place winning above the potential benefits of commitment to alternative dispute resolution, it just won't work well for your company. As I mentioned, ADR can take different forms. The prevalent ones we see are mediation, which involves a neutral who is not involved in fact finding or liability determination, but is essentially trying to work with both sides to facilitate a settlement. Arbitration does involve an individual or a panel of individuals who will make findings of facts or liability. Settlement conferences are essentially, in my experience, mediation that is operated by or overseen by courts. Many courts now have settlement conference requirements. Some courts just still encourage the mediation process, but others have quite formalized their approach. For example, the Western District Federal Court of Missouri, right after the attorneys make their appearance, they are directed to a special program they have to ensure that mediation takes place early. The last item on there, informal appraisal, is an approach that I encourage and have had some experience with, and be happy to talk with anybody offline. But basically what it is making an early evaluation of the potential liabilities and ask to speak with the plaintiff or potential plaintiff and his or her counsel in an informal setting to hear what they have to say, to let them get things off their chest. And you don't try to win the arguments with them, but you're trying to create a relationship where you can generate the ability to resolve the case early. It's very, very effective and underutilized in my view. I realize this is a kind of a 20,000, if not 30,000 foot view of alternative dispute resolution. Many of you already know what those things entail, but to be most effective, you want the provisions for ADR in whatever form that you prefer, whether it's mediation, arbitration, or some other. You want to write them into all types of your business agreements, whether they're employment contracts, your agreements with vendors, and certainly in insurance agreements. And many insurers these days have requirements for that as well. There are standards for arbitration and mediation in the arbitration setting. The American Arbitration Association, the National Academy of Arbitrators in Mediation, the American Bar Association, most state bar associations now have requirements and if not some rules regarding mediation. So some takeaways on alternative dispute resolution. To really make it work for you, you need to know where you want to save. If your company is one that is involved in litigation quite frequently, or in some types of litigation but not others, if you get a lot of employment claims, for example, and find yourselves spending a lot of money on the legal side, you may want to consider requiring some form of alternative dispute resolution within your employment agreements. In any event, identify where you're spending money, where your resources are being exhausted, and see if you can save through use of ADR. And you also want to know what your concern and motivations are. And again, this goes back to what's important to you. Certainly as a trial lawyer, I'm not suggesting there's anything wrong with a company that likes to win and wants to win. But that type of mindset can entail costs. So you need to really evaluate and ascertain what your motivations are. If you use ADR effectively, you can not only cut down those legal expenses, but you can resolve issues and disputes, and maybe even head off certain types of litigation. If you get the reputation as being a company that is amenable to early resolution, for example, and I acknowledge that there's a fear among some companies that they get pegged as an easy mark, you can control that in the way you conduct yourselves in the alternative dispute resolution settings. But ultimately, if you do it well, you can not only save costs, but you can improve relationships with your employees and the people that you do business with. I want to turn now to some insurance coverage claims issues relating to COVID-19. As Maggie mentioned earlier, we did present on this earlier this year. This isn't going to be exhaustive, but we'll touch on some of the things. And there have been some developments even within the course of this year, as COVID itself is new and we're all new in dealing with it. Some existing policies do cover companies for losses associated with viruses and even pandemics, and this usually comes up in the realm of business interruption. But many, if not most, commercial insurers had experience with earlier SARS outbreaks and put exclusion clauses in their policies for communicable diseases, epidemics, and pandemics. More specifically, many commercial insurance policies do not provide coverage or explicitly exclude coverage for communicable diseases, viruses, and some even already for COVID-19. Business interruption coverage, what is it? It's replaces business income loss typically in a disaster, like if your warehouses are hit by a hurricane, or your business must otherwise shut down unexpectedly. Does a virus pandemic qualify? That's being determined in courts throughout the country and by insurance companies in making their interpretations. Business interruption coverage, by the way, is not typically a policy in and of itself, but an add-on or an endorsement that's added on to a commercial policy. It typically covers the actual losses sustained by an insured as a direct result of loss or damage to the insured's property by a peril that isn't explicitly excluded. A typical BI clause, this is what they often look like. And you can read that and follow that on your own. Some key questions for business interruption recovery related to COVID. Was the interruption caused by a covered peril or event? And is coronavirus, or more specifically COVID-19, a covered peril under your policy? Turning from business interruption to workers' compensation, and won't spend a lot of time on this because Maggie amply covered this a few minutes ago, but it's state law based. Many states have traditionally excluded coverage for things like colds and flu, and some states have issued statements or made determinations on whether workers' comp covers COVID-19 illness. And Maggie set out some of the distinctions between Missouri and Illinois. In Illinois, as of June 5th of this year, legislation was extended to create a presumption of coverage for all employees who are first responders or among a broad variety of frontline workers. In Missouri, some first responders are covered, not all, and others must show that their workplace exposure was the prevailing factor in contracting the disease. And so the workers' comp coverage is more likely in Illinois as opposed to Missouri. And wherever state you're in, you need to check and see either with your insurance or go online and find out what your state is doing legislatively with respect to COVID, because most states are dealing with it. Coverage for COVID-related losses, you'll see clauses in the commercial general liability setting. CGL provides businesses with coverage for injury or property damage caused by the company's products or operations, applying to third parties like customers, not employees. That the employees are covered by workers' comp. Some key questions for commercial general recovery related to COVID: did the exposure come from your company or from within its premises? Is there a communicable diseases, coronavirus, or COVID exclusion in your CGL policy? And I do a fair amount of coverage work. And when I get a call from a client or a business person asking, does my policy cover this or that? The first thing I always say is send me a copy of the policy so I can look at it. The exclusions will be there or not, and you need to know what that is. Whatever policy or coverage it is at issue, the key questions will inevitably be, is there a virus exclusion or some other exclusion that may apply? If so, is it clear? Is there any ambiguity in that exclusion language? And that those of us that do some policy coverage work can tell you ambiguity is often the subject of the litigation. A typical coronavirus exclusion, some policies added endorsements explicitly excluding coronavirus years ago. There were even some policies excluding for COVID as early as last November. So the idea that we didn't know about it until January, February is not universally true. Stems from awareness following the SARS and MERS epidemics and outbreaks from earlier this century. Can a company get coverage? You may recall that the Wimbledon tennis championships were canceled this summer because of COVID. But the All England Lawn Tennis Club, which puts on Wimbledon, had purchased pandemic coverage for more than $2 million a year for the last 17 years. Money down the drain? Yes, until this year. The policy paid out $141 million, or about half the club's anticipated loss for the cancellation. Can you still get it? Other organizations have not been so fortunate. For example, USA Judo, which runs the judo program for the Olympics in the United States, their coverage ran out for COVID-related coverage in September of this year, and they can't find other coverage. And that is increasingly the case because right now insurers are still trying to map out what COVID is and what the exposure is. So it may be that in future years there'll be more specific. You'll know more about what your coverage can be. It's still up in the air with a lot of companies now. If you're wondering why college football conferences pushed to play this year, it's because their major TV contracts excluded business losses related to viruses. No games, no money. So a couple of policy examples real quickly. Under communicable disease exclusion, insurance does not apply to communicable diseases, bodily injury, property damage arising out of the actual or alleged transmission of a communicable disease. Is COVID or any virus a communicable disease? Maybe it is, maybe it isn't. But when that policy endorsement that I just showed you is attached, probably there's no coverage. Now, in a commercial property coverage setting, there's a more explicit exclusion for virus or bacteria loss. And if you see that type of exclusion, that's far more specific than the communicable disease exclusion that you often see. So some takeaways on COVID. Your insurance broker ought to be able to explain your coverage benefits and exclusions and options and future coverage options. Your insurer or its agent ought to be able to do the same. And in the end, you're always free to contact your outside counsel who hopefully can be of help to you on that. At this point, I'm going to turn things over to Ted Lucas, who's going to speak to you about releases and indemnity.
Okay. Thank you, Bart. Good morning, everybody. Thank you for joining us for the program. I'm here today to discuss releases and indemnity agreements, two very useful tools for managing your risk. So let's first just look at an example of a release, just a very simple release, all right, which is one party releasing another from liability related to a particular activity or relationship. And here's the example of a very simple one, all right. Joe Smith, a landscaper, is releasing Village Green Apartments from any and all liability for personal injuries arising from or relating to his work at the apartment complex. So he's not an employee, he's an independent contractor, and this is part of the arrangement he's worked out with the apartment complex, who doesn't want to be responsible or liable if he happens to get hurt while he's working on their property. And I'll ask you to look at this and let's imagine that Mr. Smith is cutting grass at the apartment complex. He's on the common ground and he steps into a hole and breaks his leg. Didn't see it. It wasn't obvious. Grass was tall. And I'll just, we can't raise hands and do a poll, but I'll ask you to think about it and think, do you think this language would be sufficient to get the apartment complex off the hook if Mr. Smith sued them? And if you guessed no, you guessed right. And we're going to come back and talk about why that is. But this is just a simple release, an example of a simple release. And our next slide here is just an example of a basic, simple indemnity agreement, which is a little different. It's, they're not exactly releasing you. This is when somebody's agreeing to pay your defense costs, pay for the amount of a settlement or a judgment against you if certain claims are filed against you. And there's the Joe Smith, example there, which gives you a flavor for how an indemnity agreement would be worded. This often comes up in a context where, let's say, if you have a manufacturing facility and you've got to have a contractor come in to do a bunch of, electrical work for you, and you don't, if somebody gets electrocuted, one of the employees of the contractor gets hurt, you don't want that to be your responsibility. You want that to be the contractor's responsibility. You're paying him an agreed upon amount, for his work, and you don't want to have to worry about injuries to his employees. So that's one of the contexts in which you see these sorts of indemnity agreements. Now let's talk about releases in a little more detail. Going back to what I said a second ago, that example release I showed you for Mr. Smith, and why it wouldn't work in Missouri is because in Missouri, if you're going to be released from your own negligence, your own future negligence, you have to specifically say in the release language that you're being released for your own negligence, and it has to be prominent and conspicuous. And negligence is the magic word in the release. It's got to be in there. That word needs to be in there, and it needs to be underlined or bold. It can't be hidden in the small print in a form contract on the backside of the contract or any of that, or it's not going to hold up. And Illinois is pretty much in accord with Missouri law with regard to these types of releases, except that in Illinois, they seem to put more of an emphasis on identifying the activity that the release applies to. So for instance, let's say you own a gym, a workout facility, a health facility, and your release, you would want it to say something along the lines of, customer releases us from any and all liability arising from or relating to their use of our facilities, including but not limited to playing basketball, playing racquetball, lifting weights, having a session with our personal trainer. You need to be, fairly specific in Illinois to meet their requirements. Now, I should mention, for our Marine clients, the law is a little different. The general maritime law is more generous to the party that wants the release, not as strict as Missouri or Illinois. So under general maritime law, you don't have to specifically use the word negligence or make it in bold print or, underline it or any of that. For instance, you could just say any and all liability arising from your use of our dock, and that would hold up under general maritime law. Certainly in the Eighth Circuit, it would. Now, some of you might be thinking, well, this all sounds pretty good. I ought to be having my employees sign releases. I could avoid my workers' compensation claims, et cetera. But you cannot use a release in that context or for that purpose. The state workers' compensation statutes prohibit that. You can't have an employee waive their rights to a future workers' compensation claim. It's prohibited. And you can see the statutory sites on the slide there for both Missouri and Illinois. Now, for our Marine clients, it's the same rule, except you're not dealing, of course, with a workers' compensation statute for the the employees that are working on the boats. You were dealing with the Jones Act, and the Jones Act also prohibits, releases for future injuries from employees. Now, of course, this, I'm sure it's occurring to people, well, should I be using this to try to avoid COVID claims? And I think you could, again, with regard to non-employees. So if you have a business where you have customers or vendors, whatever, non-employees that are present on your property, and you're concerned about COVID liability exposure, you could do it. But again, you've got to follow the rule here, which is if you're going to have that sort of release, it's got to be super clear, unambiguous, unmistakable, conspicuous. You've got to reference that it's going to apply even if the injuries are caused in whole or in part by your own negligence. Related note, it occurred to me, well, is the government stepping in here to try to protect businesses from COVID liability? And the short answer is not yet. There's things percolating, but nothing that's actually been passed, at least in Missouri, Illinois, and federally. And Maggie touched on this as well. Now, let's move on to indemnity clauses and hit some of the highlights on what's important for these indemnity clauses. And again, this is when you're negotiating for somebody else to pay for your defense costs, cover a settlement agreement, or a judgment in connection with some business relationship that you have with that entity. Number one, make sure the indemnity obligation is backed up by insurance. If not, it's probably not worth the paper it's written on. Obtain adequate proof of insurance. Most often what I see, when things have gone bad and there's a dispute, is that the party being indemnified just asked for a certificate of insurance during the negotiations. And that's fine as far as it goes, but you want the policy. And you'd be surprised how many times people didn't get the policy, prior to signing the agreement. Because the certificate of insurance, for instance, it'll say, company B has $5 million of commercial general liability insurance, and that's what the contract calls for. Well, that's great, except the certificate of insurance doesn't tell you anything about what the exclusions are in that policy. And so, for example, and we've seen this situation, let's say you've got a general contractor, a marine general contractor building a bridge across the Mississippi River, and they enter into a contract with a subcontractor who's going to provide iron workers for the job. The iron workers are going to be working on a barge, a flat deck construction barge, tying rebar together. Well, one of these guys gets seriously hurt or killed, and a lawsuit is filed against the general contractor. General contractor says to the subcontractor, okay, you're supposed to indemnify us for this. You've got insurance. You've got a commercial general liability policy that's supposed to cover your contractual obligations. This is a contractual obligation. Turn it over to your insurance company, and we expect them to defend this, pay any judgment, et cetera. So you do that, and you get an answer back from the subcontractor's insurance company, not so fast. We've got a watercraft exclusion in our policy. A barge qualifies, in our opinion, as a watercraft, so you're going to have to look somewhere else. So that's just an example of why it's important to get the policies up front and review them carefully, or have your counsel review them carefully. Another important consideration with regard to indemnity contracts in the construction industry are state anti-indemnity statutes. Most states have them, and they differ. Some states just outright prohibit a general contractor from being indemnified for its own negligence by a subcontractor, period. Other states like Missouri say, well, you can do it, but you've got to allow the subcontractor to get insurance for that obligation and recover the cost of that in their contract. and their liability, the subcontractor's exposure, is going to be limited to the amount of insurance that's available. So their personal assets, the company assets for the subcontractor, are not on the line. A couple more important points with regard to indemnity. Naming and waiving. These always go hand in hand with the indemnity agreement. You want to be named as an additional assured on the relevant policies, whether it's commercial general liability in the marine context, P&I policy, or a hull policy. You want to make sure that you are named on the policy. When I say waiver, naming and waiving, the waiving refers to waiver of subrogation. What does that mean? That means that if the party that's indemnifying you's insurance company pays out on a claim, they can't then turn around and sue you to try to recover what they paid out. So that's an important thing to have in your indemnity contract. The final issue is whose insurance comes first in these indemnity arrangements. For instance, and this would be in the marine context, but it applies in many transactions and business relationships. But in the marine context, let's say you're chartering your towboat to somebody else, and they're going to operate it on the Mississippi River, moving barges from New Orleans to St. Louis, and they're required to have all the appropriate insurance, P&I, protection and indemnity, hull, pollution, et cetera. But maybe you've got a little concern as the owner of the vessel that, well, what happens if their insurance lapses, or, their insurance company goes bankrupt, or something strange? Maybe I'm just going to have my own insurance, maybe a little lower levels, but I'm going to have some insurance. So now you've got two applicable policies: boat owner's policy and the charterer's policy. The boat sinks or crashes, something terrible happens, and each insurance company says, well, there's another policy that applies. They pay first. And the other guy says, no, you pay first. And now you've got two insurance companies, neither of which are willing to pay. So you want to make sure that your contract for indemnity spells out that if there are, it's more than one policy that could cover this loss, which one goes first. Then that's really all that I have, and I'm just about out of time. If you have any questions, or have any transactions underway in which you think these sorts of issues are going to come into play, we would be happy to help you with that.
That's our presentation today. One, I wanted to thank, first off, Alaris Litigation Services again for hosting us and setting up the Zoom presentation for us. Number two, of course, I want to thank everyone for attending today, particularly under these very unique circumstances. If anyone has any questions, I would encourage you to follow up with any of the presenters that you heard from today. They're happy to talk to you. I would also direct you to our firm website, where there's a great deal of information. I would ask, as Ron mentioned at the very beginning of the presentation, if everyone would fill out their evaluations and the feedback, that would be greatly helpful to us. Also, if there are any topics that people would appreciate having presented on at future seminars, we would welcome that information as well, so we can provide relevant and helpful information at future programs. Again, thank you all for attending. Hopefully our next presentation and seminar that we put on, we will be back to meeting in person. Thank you all.